Hello and welcome to this flipped learning task for law. The topic of this task is understanding the importance of fault in the law, and this topic could turn up in either paper 1, your criminal paper, or paper 2, your tort, in the 15-mark question number 9. The concept we're going to be looking at today is to what extent liability is based on fault in both criminal and civil law. Now, we've studied both criminal and tort to date, and you will have realized when learning about those different areas that fault is an essential part in the majority of both crime and tort. If you cast your minds back to crime, the most obvious measure of the fault of a defendant is in their mens rea. And you may recall that all the crimes we studied, with the exception of strict liability, have an element of mens rea. But there are different levels of mens rea, reflecting different levels of blameworthiness. In tort, we don't talk about mens rea, but we can still allocate and measure fault and blameworthiness when looking at breach of a duty and the reasonable man test, but also in the requirement of foreseeability and negligence. You may remember under the wagon mound ratio, the defendant cannot be liable for unforeseeable harm, and one justification for that is if you can't foresee it, then you can't or aren't expected to prevent it. And the other side of that coin is that if you can foresee it, or if you should have foreseen it, then you are expected to take steps to prevent it. However, both in crime and in tort, fault is not the only factor that the law is considering when deciding liability or guilt. We have seen torts of strict liability, such as Ryans and Fletcher, and we looked at the criminal area of strict liability, and you could argue that both crimes and torts of strict liability are valuing the protection of the public in general over the requirement that the defendant is at fault in the traditional way. So the law will sometimes dispense with the usual requirements of the defendant being at fault if it's felt that a greater good could be achieved, such as raising the general standard of behaviour in the population, or possibly in the case of tort as well, making sure victims don't go uncompensated. So if you look here on this slide, and feel free to pause it, you can see a couple of ways of ranking levels of mens rea in criminal law, from the most serious being intention, through recklessness, via negligence or gross negligence in our case, and finally strict liability. In tort, there's not such an easy diagram to provide. However, you can look at different levels of blameworthiness when looking at the defence of contributory negligence. That's one way that the law of tort allows the fault of both the defendant and the claimant to be compared such that the outcome is maybe fairer and reflective of the respective fault of the parties. In crime, you may recall that the most serious crimes we've looked at, murder, Section 18, require intention. You can't commit those crimes recklessly. And so that's an acknowledgement that intention is the most blameworthy state of mind, and that those crimes, being the most serious, are a reflection of that blameworthiness. It's not simply just the actus reus that determines how serious the offence is. Look at manslaughter in comparison to murder. For the unfortunate victim, they both end up dead. But manslaughter is a less serious crime, and so it's not simply the effect that you've caused as the defendant that is a measure of how serious the crime is. It's also your blameworthiness that goes towards the seriousness. And so murder is that unique crime of intentionally taking someone's life. So your flipped learning task is to produce a presentation in which you select 3 examples from any of the crimes or torts that we've studied already, and that can include defences and also sentencing that would be relevant to this topic. And those 3 examples need to show how fault is an important factor in the legal system. It could be in determining liability, it could be in determining your punishment, or I suppose in terms of tort, determining the remedy. Now, as I've suggested already, fault isn't the only thing that is at play when the law determines liability. And so in this presentation, as well as explaining where fault does play a big role, I'd also like you to show or discuss other factors that are relevant, maybe that are measured alongside fault. So in crime, you can't ignore the consequences of your actions and the harm caused in determining liability, and you can find examples of cases of crimes where it's not just the mens rea that determines what crime you're liable for, but the consequences of your actions as well. Other factors might be to do with public policy, especially in tort. You may point at where there's fault in one of the torts we've looked at, but also where public policy, maybe the floodgates argument, maybe who has deeper pockets, ensuring that the victim doesn't go uncompensated, maybe who is in a position to get insurance. These policy factors can also play a role in deciding whether or not the defendant was going to be liable. So in your slideshow, I need to identify 3, at least 1 tort and at least 1 crime or criminal element. In addition, I'd like you to find 1 crime or tort where there is no fault required. And this because in the exam you may be expected to discuss the extent to which fault is important, and in that discussion you'd have to include examples where fault isn't required, as an example of where the limitation of the importance of fault lies. So if you pause, you'll see on the right hand side some examples, some suggestions. These are by no means the only ones you could pick. You may have noticed other ones I've mentioned earlier, or you may already think of some yourself. So, I look forward to seeing your presentations in class. Remember, this topic is relevant to either paper 1 or paper 2, although obviously it wouldn't turn up on both in 1 year. But no matter which topic, or sorry, which paper it turns up on, you can give examples in both areas. So if it comes up on the crime paper, you're fully entitled to discuss tortious examples and vice versa. So please look for both criminal and tortious examples in your presentation.